Members, good afternoon. It's the appointed time. We have a quorum. This is the second meeting of the Bills Committee on Protection of Critical Infrastructure's Computer Systems Bill. Let us first invite the administration to join us. Agenda item number 1, meeting with the administration. We have with us Ms. Wong, Deputy Secretary for Security, Ms. Michelle Choi, Principal Assistant Secretary, Security, and Mr. Francis Chan, Assistant Director, Critical Infrastructure from the Security Bureau. We also have Mr. Ivan Leung, Principal Government Counsel from the Department of Justice, DOJ, Mr. Gary Lee, Senior Assistant Law Draftsman from the DOJ as well. We have Ms. Kenny Chan from the Digital Policy Office and Ms. Carmen Leung, Senior Superintendent of Police from the Cybersecurity Forensics and Training, Cybersecurity and Technology Crime Bureau of the Police Force. This is a 4-hour meeting. I thank the administration for your support. We'll make good use of the time to scrutinize the bill. Depending on the progress of the meeting, I will arrange for a 10-minute break. On the 7th of January, last Tuesday, following the meeting last week, we have published on the internet to announce that we have invited the public to submit written submissions on the bill. We have also informed the 18 district councils of the invitation. The deadline for providing us with the written submissions is 5 o'clock on the 21st of January. Members, please refer to CB 236/2025/01 in relation to the list of follow-up actions arising from the meeting on the 7th of January 2025. I'd like to invite Ms. Wong, Deputy Secretary for Security, to walk us through the list of following up actions. Members also have the administration's response to the issues raised at the last meeting. The paper is LC paper number CB 236/2025-02. I will open the floor for questions after the administration's response. Thank you. Thank you, Madam Chair. In this paper, we provided our response in relation to the follow-up actions. When someone discloses a critical infrastructure or the CI operator identity without any legal authority, is someone held criminally liable? We have a preservation of secrecy clause under Clause 57 of the bill. Members can refer to Clause 57. Except in the performance of any function under this ordinance or for carrying into effect the provisions of this ordinance, a specified person must not disclose any information. This is provided under Clauses 57 and 58 of the bill. Out of security concerns, we won't set out the CI operators or the identity of the individual operators. As for the identity of the CI operators, we'll keep them as classified, and they are protected under Clauses 57 and 58. Any disclosure without lawful authority will affect the Hong Kong SAR, and we will keep such information classified. Having said that, we didn't ban any persons apart from that from disclosing information. However, the police force will track the information and the way in which the information is obtained to carry out investigation. This may lead to other offenses such as theft under the theft ordinance or access to a computer with criminal or dishonest intent under the crimes ordinance. Simply put, in view of the target of the bill as well as its scope, we already have a preservation of secrecy provision. The list of CIOs as well as the identity of CIOs shouldn't be disclosed. They are protected in accordance with the preservation of secrecy provision. The source of information and the way in which the information is accessed will be investigated by the police. If the offense elements are met, the offender may be held criminally liable. Will Madam Chair allow members to ask questions? Well, probably you can walk us through the entire response first. Thank you. 2. Will we impose liabilities on the owners of the critical infrastructures, CI? In the consultation period, we have received views on the difficulty in report on the change in ownership, so we have removed such a requirement. The bill targets mainly operators. Change in ownership may be frequent, as large companies may be listed companies. In addition, owners may not be directly involved in the operation of CI. So in this connection, we won't impose liabilities on the owners of CIs. However, if CIO owners are the operators of the CIO as well, and if they are involved in the daily operation of CIs, subject to the fulfillment of the consideration of CIOs, we may appoint that person to be the CIO. Then they will have to fulfill certain responsibilities as a result. In the investigation or any emergency response plan, if we need them to provide information, we may request owners to provide information. As for the consideration of appointing sectoral regulators as the designated authorities, the bill has appointed the Hong Kong Monetary Authority and the Communications Authority as the designated authorities. They are responsible for financial services as well as telecommunications services. That is Category 1 obligations and Category 2 obligations. We take into account a series of factors, such as the main functions, target of regulation, including the number of potential regulators, the number of potential operators, regulation authority, as well as the scope. 2. Whether the regulators have issued guidelines in relation to computer system safety and the contents thereof. 3. Appointing such regulators as the designated authorities to achieve the aim or purpose of the bill overall. The government reviews the list of designated authorities from time to time. If need be, the Security Bureau can exercise Clause 70 of the bill and amend Schedule 2 to the bill, whereby the administration can appoint the sectoral regulators as designated authorities. In relation to 4, whether the Commissioner's responsibilities should include to monitor, investigate, and respond to computer system security threats and computer system security incidents in respect of the critical computer systems of critical infrastructures. If this will give rise to widespread impacts on the public, then the Commissioner will have to make announcements to the public. So we don't have to settle separately such a liability. Generally speaking, if operators run into computer system security incidents, they should activate the emergency response plan depending on the situation. And that is provided under Schedule 3 of the bill. That concludes my introduction. Thank you, Madam Chair. Members who would like to speak, please press the button to request to speak. We have 3 members right now. 5 minutes for each member, questions and answers included. Thank you. Dr. Ben Chen. Thank you, Madam Chair. The Deputy Secretary's explanation is clear. She has addressed our concerns, but I'd like to see clarifications on a few points. The operators do not have any responsibility, and that is in response to the industry's concerns. If the operator knows that the owner does not have to exercise management or regulation, is it true that the operator cannot inform the owner? In a process, who should inform whom? Who should inform the owner? If the owner does not shoulder any responsibility, will there be a provision setting out anyone, including the owner, cannot meddle in the operator's compliance with the Commissioner's guidelines or instructions? If not in the compliance of the instructions, other issues on resources may be incurred. Who is to be held responsible? Thank you, Madam Chair. Thank you, Dr. Ben Chen, for your questions. The statutory responsibilities target the operator. If necessary, if the owner requests further resources in order to comply with the instructions, it is also possible that one have to engage a service provider. So in order to comply with the instructions, one may have to disclose the identity of the operator. We understand we cannot rule out this possibility. It's possible to have this occasion. So in paragraph 5 of the reply, in compliance with the responsibilities under the bill, or in situations where it is necessary to disclose the identity to the supplier, professional service providers, or any other person, the authorities can provide further appropriate guidelines in the code of practice in the future for the reference of operators. If someone needs to disclose his identity as a CI operator in order to comply with these statutory requirements, one has to make sure that the provision of such information will be kept in secret. Contracts can be entered into. Other methods may be used to make sure that information is classified and will be kept in secret. Dr. Ben Chen, thank you for your reply. Owners have a responsibility that he or she cannot evade. In order to comply with the requirement, one may need to provide resources. One may also need to engage a qualified professional to operate the facilities. In my example, the operator may have to inform the owner. The operator may be skeptical, or the operator may not act accordingly. The owner may not be in Hong Kong. The owner does not wish to comply with the requirements in relation to critical infrastructures, or someone may deliberately not provide any information. They just leave you to it. In these situations, there may be a negative impact on the critical infrastructures. The legal requirements may not be complied with. So you may consider asking the commissioner to inform the owner, so the operator will not be worried whether he or she has a responsibility for disclosure. That is because if someone is an operator, then there may be issues. If the commissioners provide instructions, then there won't be any problems. That is because the operator knows that the commissioner has such an instruction. Owners have the responsibility to act accordingly. Deputy Secretary, do you understand what Dr. Ben Chan means? You have addressed the concerns of the public. In relation to the change in ownership, it may be difficult for large companies to report any change in ownership.
Chair. The owner of the critical infrastructure, large-scale critical infrastructure, there may be constant or regular changes to the ownership of the critical infrastructure. For listed companies, in particular, there may be numerous owners. So who should be defined as the owner? The largest shareholder or other criteria? So we need to define first who the owners of the critical infrastructure are. Before the public consultation, we intended to require owners of critical infrastructure to declare ownership, but there were difficulties according to the stakeholders. So we would define the responsibility of the owners according to the resources they own. Now, if we required owners to declare their ownership to the commissioner and at the same time report incidents to the commissioner, that may be difficult to enforce. After all, we need to sit down with the organization to understand who the owner of the critical infrastructure is. We can't rely on the commissioner to arbitrarily decide who the owner of the CI is. There are a lot of concepts to clarify who the owners are. Do we need the owners to notify the commissioner about any changes in ownership? So these are all questions arising from the difficulties in defining ownership and changes in ownership. So we now target the CI operators only. The services provided by the CIOs are of a critical nature, as the name suggests. So the organizations themselves have the obligations and intent to maintain the stability and security of the critical infrastructures. That's why we have received a lot of support during the consultation stage. So it is not probable that the owners evade responsibility deliberately, because there would be a consequence for the operators and the owners if they did so. And we are pleased to see that many operators and owners have updated and enhanced their operating system on the eve of this bill. And as I said, there would be a consequence for the owners or operators if they fail to comply with the requirements under the bill. So we think the current manner of drafting fulfills our purpose. Mr. Shanghai-Long, thank you, Chairperson. I raised the same question about Commissioner last time around. In Part 2 of the bill, Section 3 and 4 about Commissioner, the powers of the Commissioner were clearly defined. There are 7, from defining and designating critical infrastructure operators to enforcement power. However, according to the trades, the requirement to report incidents within 4 or 5 hours, otherwise there would be a $4 or $5 million fine. That depends on when the Commissioner defined something as a critical infrastructure incident. And also about the codes of practice, the COPs. I had a talk with the sectors. And like Ms. Vega Wong said, COPs will be issued in relation to the industries. However, under each industry, there are niches of services. For example, B2C or B2B businesses in the telecommunication business. So will a single COP under the broad category be sufficient to cover all the operations? Well, I believe the natures of services provided in each industry is limited, so I think there should be a separate code of practice for each operator. Deputy Secretary. Thank you, Chair, and thank you, Mr. Chang Hai-lung, for your question. Concerning the time limits for the Commissioner to make a reply, we haven't specified that in the bill. It depends on the nature and severity of each incident. Of course, the idea is to ensure that the incident is being handled promptly. Now, when the bill is passed, after accumulating experience, maybe we can define and specify a period within which the departments should address the incidents, just like the service pledge made by some government departments. So after the law has been passed for some time and when there are sufficient experience accumulated, we may be able to set practical targets. That would be a more practicable approach. On the other question about COPs, do we need a separate set of COPs for individual CIOs? Now, the COPs will be flexible in nature. However, we do think that there will be COPs for CIOs engaging in specific operations. When the CIOs themselves have an alternative set of COPs which is comparable to our standards, we will accept them. So that would be a virtually tailor-made set of COPs for the operators. There will be a master COPs for the sector or the industry as a whole. However, we will accept comparable COPs adopted by individual operators. So in these cases, if CIOs choose to follow their own alternative procedures, which is comparable to our COPs, we would deem it acceptable. Whether we would tailor-make COPs for individual CIOs, or that may jeopardize the consistency of our approach, so we will stick to the existing practice. Mr. Frankie Yik. Thank you, Chair. On the last occasion, I was on a business trip, so I was absent. So I do apologize if my questions overlap with other members. I've talked to the relevant stakeholders, and they are generally agreeable to the principal ordinance. But they have a lot of questions about the upcoming COPs. Let me give you two examples. For example, the security management unit. What kind of experts do we need on the team? Do we have the talents in Hong Kong, and will the operators be given sufficient time to hire these people? Second, about material changes to the system, which is reportable. The definition is very wide. What kind of incidents or what kind of material changes need to be reported? Third, for major computer system, usually third-party service providers are involved. Parts of the legal responsibilities should be borne by the third-party service providers. However, for those contracts already awarded, the contractors may refuse to bear any legal responsibilities. So I hope we can have a sit-down with the administration together with these stakeholders to follow up on how the concerns can be addressed in the future COPs. Thank you. Although Mr. Frankie Yick's questions are unrelated to the follow-up replies, I think they are very pertinent, so I will allow the questions. Thank you, Mr. Yick, for your questions. About the security management unit. And the person in charge expertise. In clause 21 of the bill, it is specified that the CI operator must appoint an employee of the operator who has adequate professional knowledge in relation to computer system security to supervise the computer system security management unit. That is clause 21, brackets 4A. We haven't specified the sort of professional knowledge and experience required for the supervisor of the security management units in the bill, because according to the trade, there are other talents with alternative experience and expertise which can also deliver the job. And also there may be new skill sets being recognized in the market. So those will be announced through COPs rather than by the bill. And also, the operators are allowed to set up an internal security management team or engage a third party to take the job. So the expertise required would be different under the different approaches. So we don't think it is appropriate to specify the specific requirements for the experts for the security management team, considering that the trade needs to keep abreast with time. We think it is more appropriate to announce referencing qualifications in the upcoming COPs for the trade's reference. That being said, the qualifications mentioned in the future COPs will not be the only standard we accept. Other up-to-standard qualifications will also be accepted. About the reporting requirements of material changes. Sorry, that should be the material changes to a system. How do we understand the term? Thank you, Chair. To put it more accurately, that is material changes to the critical computer system. That is Clause 22. Clause 22 gives examples of these. For example, bracket 3. Now, without defining the term material, without limiting the meaning of material, there are some changes which need to be reported. For example, if the change affects the computer system security of the critical computer system concerned, or the ability of the CI operator to respond to a computer system security threat or computer system security incident in respect of the system, or makes any information provided in respect of the system for compliance with the requirements imposed under Section 16 no longer accurate in a material particular. So if the changes render the previously reported information about the critical computer system invalid, then a report is needed. And also if the change affects the response capability of the CI operator in respect of an security threat, report is also required. Bearing in mind that technology progresses quickly, we need to preserve some headroom for the operators. Now, on the legal responsibility of third-party service providers, we do understand that this is quite prevalent in the trade. As we have mentioned on previous occasions, you can outsource the work but not the responsibility. In the future, by way of COPs, we will recommend clauses in contracts for hiring third-party service providers to require the third-party service providers to provide the information and cooperation in case of an incident so as to protect the CIO's interests. For existing contracts, which cannot be amended, it is still the CIO's responsibility to consider whether another third-party service providers should be engaged for compliance with the law. In designating the CIOs, the Commissioner will also consider the preparedness of the CIOs. Now, in a discussion with the CIOs, if it is found that the existing service delivery models cannot fully comply with the new standards, if the preparedness is insufficient, then we will consider designating the operator as a CIO only in the second phase. That concludes my response. Rest assured, Mr. Yik, we will continue to keep in close contact with the trade. We welcome any questions from the trade, and we look forward to reassuring them through explanation. Mr. Frankie Yik, first I thank the Deputy Secretary for her explanation. Now, when the COPs are set, I really hope that the concerns of the trade can be fully addressed. Let's keep in touch. Next, Mr. Benson Look. Thank you, Chair. I would like to follow up on paragraphs 6 to 9 in the reply. That is ownership and operators of critical infrastructure and their respective responsibilities. The administration stresses that the bill seeks to regulate operators only. The shareholding structure of many organizations, in particular CIOs, in particular listed companies, are complicated. So we need to maintain a flexible business environment in Hong Kong. So I support your arrangement. As an owner of the critical infrastructure, I presume that they would like their infrastructure to be safe and in compliance with the law. So I believe they are eager to do better. I have two questions for the administration. For public utilities, say for example, the same groups of companies may be the owner and the operator at the same time. So they will be held up to the standards in the bill. However, if there is a divorce between the ownership and the operating role, how can we ensure that the owners know that their infrastructure is of a critical nature, and also the contractors? How can we be sure that they know that what they are operating is a piece of critical infrastructure?
Secondly, I understand starting from 2023, the Bureau has organized 40 briefing sessions, 100 organizations and 500 people attended those sessions. I would like to know whether they have covered issues such as conflicts between owners and operators, etc. Or they indicate the same preference. Mr. Look, this is a similar question to the question asked by Mr. Ban Chen. I think that's a question about the use of a third-party contractor, service provider, in order to comply with the regulations. Well, thank you for your support. That we would like to do something about the report by the Commission for material change. So we have been focusing on the owner. What about the operators or other people, other parties? Well, in theory, if they don't have a responsibility to discharge a duty, then there's no need for them to know. But if the operator has certain legal responsibility to discharge, then there's a responsibility for the operator to disclose his status as the operator. But of course, there may be other channels such as contractual provisions to preserve the secrecy of the relevant information. As for the second question, whether there's any conflict between the owner and the operator, during the briefing sessions, we haven't anything about the potential conflict between the owner and the operator. I believe they share the common goal to run the CI in a secure manner, because these CIOs are offering services which are essential to the general public. So they share the same goals, and they are willing to cooperate with the administration. And if the trade would like to see something reflected in the COP, which may result in
need to upgrade what they are doing, they are more than willing to comply. Just a follow-up question. The operator might have outsourced the relevant tasks. Is it a requirement for the operator to stipulate in the contract that this is a CI and that the contractor must fulfill certain standards before they can offer their service? Whether it should be stipulated in the tendering process for outsourced services? Well, in the law, there are certain legal responsibility, for example, for assessment and vetting. If they ask a contractor to do this, to do the assessment, and then the operator has to ask the bidder to do the assessment as stipulated in Schedule 3 and Schedule 4 in order to comply with the law. So in the process, he can specify that they have to comply with the requirements. So in this case, well, he may have to disclose his identity as his status, but that in the contract itself there must be a preservation of secrecy requirement. There must be some secrecy clauses included in the contract. We would provide some reference information in the COP so that when the operator secures the service of a third-party contractor to do the assessment, and the contractor is asked to refer to the requirements in the ordinance, then in a way he has disclosed his status. So that would be the arrangement we have in mind. Ms. Carmen Can, Ms. Elizabeth Quat. We have been told by the administration that the operator and the owner would share the same mindset. But for some CIOs, they may be in possession of certain construction plans or distribution charts, and someone outside Hong Kong may want to ask for such information. Can such request be declined to an outsider, to a contractor outside Hong Kong? As for the relationship between the CIO and the third-party service provider, of course, in the future, they have to comply with the law. The contract will have to be drafted in accordance with law. But what about contracts that were signed years ago? They didn't know the requirements or the fact that there will be a new law. And according to the administration, the operator will have to find a way out to comply, whether it would incur additional costs or not. So the operator has to fulfill its responsibility in any case. Deputy Secretary, regarding the first question, the operator and the owner or the shareholders might need to share some information, or how should they communicate? In the law, there's no stipulation on what contents can be communicated. We're not trying to interfere with the communication between the operator and the owner, maybe in respect of certain technical requirements, they may need to know the distribution diagram, distribution plan, or the location of certain critical infrastructure. If there's a need to know situation, then the bill doesn't really prohibit such communication between them. But the bill requires the owner, which are designated as a CIO, and in this bill there will be communication between the commissioner and the CIO. For example, the submission of certain reports in the law, then we have this preservation of secrecy requirement. And even if there's a disclosure, or even if a third party obtains the information from whatever sources, and I would just want to say that we are not trying to regulate the communication between the operator and the owner under the bill. As for pre-existing contracts with new security stipulations in the law, then certain things can be done. First of all, contracts can be altered or amended, and secondly, a contract is only valid for a certain period. That's why I have said that we would consider phasing in the requirements depending on the preparedness of the operator and the targets of our regulation. We will only designate these operators after they are ready. All right, now I would like to ask some follow-up questions. As for the 4 issues, I think we are all concerned about the need to follow up the relevant issues. With regard to the first response, according to you, Clause 57 is really about regulating the preservation of secrecy is only going to affect the specified person. And also, they know that they should not disclose information against the stipulations. But there are certain parties who are not operators. You are saying that the operator can disclose the information to the shareholders or owners or the third-party contractors. We are concerned about a non-specified person, which is not a third-party contractor. You are saying that they should regulate the conduct of their own employees, and you are going to provide certain reference template in the COP. Please give us some example. In paragraph 8 and 9, paragraph 9, you mentioned that if the certain operator really operates the specified CI, they may be specified as such. As for group companies, the owner may also have access to the information or may have certain managerial responsibility of the CI. So these parties may also be specified. So that's our response in the second question. In the third issue, well, I welcome your indication, your response that there will be regular reviews. And this time you would involve Hong Kong MA. And what about other regulators? They are not a specified authority at this stage. The answer from you is yes, not at this stage. But you will be review the situation. For example, last time we mentioned MPFA. There will be EMPF platform, and you are not ruling out this from the MPIT. But you have to scrutinize other laws. And also you mentioned the 3 factors that you want to consider. So I welcome the response that there will be regular review. But maybe during the scrutiny of this bill, you may come to certain views. And also the Commission is obligated to disclose certain information. This is in respect of the 4th question. You don't want to impose this as a responsibility, and the disclosure of a security issue is not a legal responsibility. Can you elaborate a bit on this part? At present, one of the responsibilities of the Commissioner is to monitor and also threats to critical infrastructure. And we are saying that depending on the circumstances, he should do certain things. This is the legislative intent. CIO's identity is kept confidential, but they are providing essential services, critical services to the public. If there's an incident which will affect or to significantly public services, then there will be a need to make a public, to announce it to the public. Maybe it's due to the stoppage of a certain essential services. In this case, the event is already in the public domain because the public are already aware of the disruption or stoppage of the service in question. And the bill also stipulates that notwithstanding the preservation of secrecy requirement in the clause 57, what if the relevant information is already publicly known, then it will not be a problem. So that's how this is worded. That is in relation to respond to the stoppage or disruption of certain essential public services. And the response plan would we involve advising the public to use alternative services, as we mentioned in paragraph 14. The operator may have a responsibility to announce, the Bureau may have to announce the emergency response plan. For example, how to access alternative services. So on the whole, we don't think there should be another clause to provide an across-the-board requirement that the Commissioner must alert the public.
Next, Mr. Kong. Thank you, Madam Chair. It's only just now that I knew how to put this question right. Thank you. Even if we do not regulate the owner, there won't be any issues. I'd like to ask a situational question. CIs have a wide coverage. When owners of CI receive threats such as ransom in Australia, if someone receives ransom request, someone would have to make a police report. If the owner of CI is threatened, it is not like interfering with the system. Someone is just requesting ransom from the CI owner. Unbeknownst to the operator, I mean, as it is the owner which has the money. Is there any loophole? If a bad individual holds the owner of the CI to ransom unbeknown to the operator, if the operator doesn't know the situation, does the owner still need to report the situation? Deputy Secretary, please speak into the microphone. If the owner is under threat to pay ransom, other criminal ordinances will be invoked. This situation isn't covered under the existing ordinance. Regarding whether the operator knows that the owner is being held to ransom, this situation doesn't fall under the purview of this bill. We don't aim to regulate these situations. In this situation, we recommend the relevant party to make a police report. It is not a criminal offense under the purview of the Commissioner. The Commissioner won't see to such incidents. Mr. Kong, I'm not going to ask further, but I hope the administration will understand that it's difficult to cover all scenarios. The administration, not least the Security Bureau, needs to think about these situations. Ransoms are common in relation to critical infrastructures, and you cannot rule out the possibility that those being held to ransom don't want to make a police report. They want to avoid trouble, and that's exactly why the legislation in Australia requires those being held for ransom to make a police report. I just want this to be recorded. So please take note of that, Security Bureau. Thank you. Any more member would like to ask questions? No? We're going to start the clause-by-clause scrutiny. The administration replied to the Council CB-21779/2024-01. So I'd like to ask members. We'll first start with the scrutiny on the Chinese text. If the legal advisor deems necessary, please remind members of what to pay attention to. Please use the blue bill. This is a new legislation and we don't have a marked up copy. Members, please refer to CB-21617/2024. Let's get started with the Chinese text. And please ready the administration to walk us through the bill. We have a total of 70 clauses as well as 7 schedules. Let's scrutinize the bill seriously. There are 4 meetings for the scrutiny of the bill. Let's see if we can complete the scrutiny within 4 meetings. The administration may also refer to the schedule if need be. Thank you. Deputy Secretary, may you please take us through the bill? Thank you, Madam Chair. If we are going to start the clause-by-clause scrutiny, I suggest asking my colleague Ms. Choi to brief members on the summary of the clauses. Then my team and I are happy to take questions from members. C2899, the long title, explains that the bill aims to protect the security of the computer systems of Hong Kong's critical infrastructures, to regulate the operators of such infrastructures, to provide for the investigation into and response to computer system security threats and incidents in respect of such computer systems, and to provide for related matters. There are a total of 8 parts. Part 1, Preliminary. Part 2, Regulating Authorities. Part 3, Critical Infrastructures, CI operators, and critical computer systems, including requiring information. Part 4, the 3 categories of CI operators. Part 5, responding to computer system security threats and computer system security incidents. Part 6, investigation of offenses. Part 7, appeals. Part 8, miscellaneous provisions. If members have no questions, let's move on to Part 1, Preliminary, Short Title and Commencement, Interpretation, Clause 1, Brackets 1, Short Title, Brackets 2, the ordinance comes into operation on a date to be appointed by the Secretary for Security by notice published in the Gazette. Please pause. Mr. Lai Tong Kwok has a question. Thank you, Madam Chair. I thank the legal advisor for sending the administration letter on the provisions. We sought clarifications in the letter. The administration just now provided us with a reply. I suggest whenever we come to points at which the legal advisor asked about, I invite the administration to walk us through their responses as well, so we won't miss out on any details. Agreeable, administration? Yes. Thank you, Mr. Eng Kong. Thank you, Madam Chair. In long title, regulate the operators of such infrastructures. Can we discuss whether this bill regulates the operators of such infrastructures or the operation of such infrastructures? Of course, I know the person in charge is the operator of the infrastructures, but we don't regulate the operators. Instead, we regulate the operation. Correct me if I'm wrong. I'll give the floor to the DOJ. DOJ, Lord Draftman. In the bill, it covers many obligations imposed on the operator. So we are indeed regulating the operators. But meanwhile, we protect the computer system security of critical infrastructures. Any follow-up? No. Thank you, Mr. Eng Kong. Just now, the Deputy Secretary talked about subclauses 1 and 2. Any question? No. I'd like to ask a question. By notice published in the Gazette, Have you taken into account the time needed, that is, upon passage by way of third reading, you will need time to prepare the code of practice and maintain liaison with the industries according to Schedule 1. In the PowerPoint, you mentioned around 1 year. Is my understanding correct? Will you also consider making progress reports as appropriate to the panel on security at the Legislative Council? Yes, Madam Chair, you are correct. After the bill is scrutinized and passed, it won't come into operation right away. We will appoint a date as we have to complete preparatory work. We'll have to go to the establishment subcommittee to create new positions, say those under the commissioner's office. We will also continue to maintain a close dialogue with the trade in relation to the code of practice. It takes time to prepare the COP. We hope that the bill, in the first half of 2026, I hope the bill will come into operation around 1 year after it is passed. Regarding making reports to the panel on security will depend on the progress. We'll have to create a handful of directorate posts. We'll take the opportunity to submit further information to the panel. We will also let the panel know the latest information on our preparatory work. Next, on to interpretations. I'll select a handful of important definitions to explain to members. In the interpretation of designated authority, it's in Section 5. Simply put, the Hong Kong MA and the Communications Authority are the regulating authorities. They are responsible for different industries. Hang on, Mr. Lai Tong Kwok has a question. Well, can we go through the interpretations one by one? There was an interpretation that I wanted to ask. In clause-by-clause scrutiny, we indeed should scrutinize the interpretations one by one. For some interpretations, they directly refer us to a particular section, so the administration can simply refer us to the particular section under the interpretation. However, please take us through all interpretations. No problem. The first one, Appeal Board. It will be handled under Section 4, Brackets 1 of Schedule 7. Appeal Panel also under Section 47, Brackets 1. Document includes any input or output in whatever form into or from an information system, and any document, record, information, or similar material, whether produced or stored mechanically, electronically, magnetically, optically, manually, or by any other means. Regulated organization in relation to a designated authority means an organization specified in column 4 of Part 2 of Schedule 2 opposite the authority. I'd like to ask about documents. The interpretation here differs from that under Cap 1. You have your own considerations in relation to the interpretation of document. Can you tell us more from the perspective of drafting? I'll give the floor to the DOJ. Thank you, Madam Chair. This is in relation to the regulated organizations. So we have specified any input or output in whatever form into or from an information system as well as other electronic documents. Mr. Wang Kong indicated that she wishes to speak. Thank you, Madam Chair. Madam Chair, I thank you for asking this question. When we apply for a magistrate's warrant to enter premises to obtain documents, I'd like to ask the administration, according to the definition of documents, does it only cover hard copy? If you include hard copy, say in brackets B, if hard copy is included, you shouldn't use the word document. It's quite misleading. It is like a document in the context of clerical documents. Thank you for your question. In critical computer system, the documents may not be paper documents. They may not be in paper form. So especially in brackets B, any document, record of information, or similar material, whether produced or stored mechanically, electronically, magnetically, optically, manually, or by any other means. We have regard to the unique feature of the relevant documents. We want to cover all non-paper form documents. I have a follow-up. Thank you, Madam Chair. I know there's the interpretation of information under the bill. Information has a wider definition than document. When I obtain a warrant to enter premises to get documents, there are both documents and information. In relation to the legislation in Singapore, the administration there has access to information, not just document. I'd like to know the reason why the administration put it this way in the legislation. We covered information as well. It includes data, text, images, sound codes, computer programs, and so on. The scope of information is wider than that of document. I can ask the DOJ to give you more information. Say sound codes are included as well. For document that I just mentioned, it differs from paper form documents, as Ms. Dorian Kong said. Because of the uniqueness of the bill, we cover documents of other formats as well. In relation to information, the scope is wider than that of documents. We want to make clear document covers non-paper form document or non-paper based information. And information isn't limited to documents. It includes computer programs, software, databases, images as well. We have different considerations, and they are different. Thank you, Madam Chair.
Any supplements from the Law Drafting Division? As the Deputy Secretary said, information is intangible. It covers those articles mentioned in the interpretation clause. Now, for documents, it is a vessel of information. It can be a record of information, or information that is stored mechanically, optically, and manually. So document refers to tangible things. Now for information given via questions and answers, that is not tangible. Ms. Doreen Kong, in Part B of the definition for documents, it refers to record of information. So the document here refers to a format of record of information. The definition of document in the context of this bill covers the situation mentioned by Ms. Kong. Any follow-up questions from Ms. Doreen Kong? Thank you. Now, my concern with B is that it is phrased whether produced or stored. I wonder whether we should extend the definition to processed as well. Last time, Ms. Elizabeth Quart mentioned that the information may be in transit or being processed. She's worried that the information would be lost during the process. So does Part B of the definition for documents covers the situation mentioned by Ms. Elizabeth Quart? Lord Draftsman, I refer members to the definition of document itself. Right off the bat, it says document includes. It means that the definition is not exhaustive. Part A and Part B of the definition should cover all tangible and intangible information, hard copy and soft copies of information. These are all covered by the definition. Concerning the definition of information, as mentioned by Ms. Doreen Kong, I suggest that we leave it for later. In the subsequent parts of the bill, there are provisions requiring operators to make available documents and also powers of the commissioner to conduct investigation on documents or information. We might leave the discussion to that part. The document includes a wide range of vessel of information. Thank you. Ms. Lai Tong Kwok. Thank you, Chairman. After the discussion just now, in my opinion, the interpretation is quite complicated and quite hard to grasp. Now, right off the bat, you use the word include. In other words, there are lots of things not being specified in the definition. A lot of other articles can be considered documents because you are not limiting the definition of documents to paper-based documents. And Part B any documents, record of information or material produced or stored mechanically, or Part A, any input or output in whatever form. So information being entered or generated are also documents, which may constitute the meaning under Part B. So that's very confusing. So I think Part B is comprehensive enough. Why do we need Part A in the definition? Lastly, I agree with Ms. Doreen Kong. There is a lot of overlapping between the definition of information and documents. Of course, we may have a better understanding why we need two separate terms in the subsequent parts of the bill. Here, I don't see why it is necessary. There are two different definitions for documents and information, but I am worried that there may be overlap and it may lead to confusion. Thank you. Any explanation about Part A of the definition? Thank you, Chan. Thank you, Mr. Lai. Part A, any input or output in whatever form into or from an information system. As mentioned by Chair, data being entered may be in transit or being processed. The same applies to output, which also involves a process. Information can be stored in various formats, either dynamic or static. So we want to cover all these data formats. That's why we seek to define that in Part A. And we use the word includes rather than refers to. Because when it comes to critical computer system, it involves technology, and technology evolves on a daily basis. The format of information, well, the terms inputs or outputs may not apply to the latest formats of information in the future. A piece of document may be stored in a computer without being input. Now, considering that we choose to use the word includes to be flexible. Now, the idea is that a document must involve inputs or outputs, but we don't rule out any other possibilities. That's why we choose not to capture the definition at this point. Even when the format changes, as long as all the constituents of the definition are fulfilled, the definition can still apply. Thank you. So as suggested by Mr. Lai Tung-kwok, when we come to the relevant provisions, we will have a better grasp of how the definitions can apply. So if the definition refers us to a certain part in the bill, we will just wait for the relevant part. Next definition, a regulated organization. In relation to a designated authority means an organization specified in column 4 of Part 2 of Schedule 2 opposite to the authority. Courts means a court as defined by Section 3 of the Interpretation and General Clauses Ordinance Cap 1 or a magistrate. Mr. Lai Tung-kwok. Thank you. Now, definition Part A of courts. A court is defined by Section 3 of Cap 1 or a magistrate. Does it include the relevant tribunals? If that is so, Part B specifies magistrates as well. So do we need to include presiding officers and tribunal officers and so on? Administration. Let me give a reply and then I will defer to the DOJ. Part A of the definition for courts. Courts defined by the Interpretation and General clauses ordinance. It doesn't include tribunals. That's why we need to spell it out clearly. DOJ, Mr. Ivan Leung. Now, for tribunals, some of them exercise judicial functions. For example, Lands Tribunal and Labor Tribunal. There are also statutory tribunals without judicial powers, but all the same, they are called tribunals. So the court here means the courts which exercise judicial functions. There are several clauses in the subsequent parts. One refers to the COPs, that non-compliance of COPs can be used as an evidence in courts. That's why we have to define courts. For tribunals or statutory tribunals exercising non-judicial functions, they are not related to the bill. As a result, they are not covered by the definition. Mr. Lai, Chair, if you refer to the definition in Pt.1, a court refers to any HASAR courts with jurisdiction. So are tribunals with jurisdictional power covered? That's my question. DOJ, Mr. Lai would like to know do tribunals with jurisdictional power form part of the definition? Yes, they form part of the definition. Usually, these tribunals would be called court of records and so on. So there should be references that these tribunals are actually courts. Magistrates are another thing. That's why we have to specify it separately. Now, for courts which exercise jurisdictional power, magistrates would apply as well. However, the definition of court covers all the tribunals mentioned by Mr. Lai Dongguok. Next, designated date in relation to a CI operator means the date on which the operator is designated under Section 12. Designated authority, see Section 5. Designated critical infrastructure, another part in the bill. Core function in relation to a critical infrastructure means if the infrastructure falls within paragraph A of the definition of critical infrastructure in this subsection, the provision of the essential service concerned, or any function of the infrastructure that is essential to the maintenance of critical societal and economic activities in Hong Kong. Any questions about the definition of core function? This is a common term. Commissioner, Section 3 will deal with it. Categories, Category 1 to Category 3 application, these will be defined later. Regulating authority, a commissioner or the designated authority. Information, we have covered that. Information system has the meaning given by Section 2.1 of the Electronic Transactions Ordinance, Cap 553. Computer system, means a set of computer hardware and software, or includes a computer. Now we try to extend to make the coverage as wide as possible to cope with future technology advancements. Computer system security in relation to a critical computer system means the ability of the system to resist any state in which the system is protected from events and acts that compromise the availability, integrity, or confidentiality of the information stored in, transmitted, or processed by, or accessible via the system, or the services offered by, or accessible via the system. Mr. Lai Dongguok, I would like to go back to the differences between computer system and information system. What are the differences between the two kinds of system? Administration, DOJ. Thank you, Chair, and thank you, Mr. Lai. First, on information system. The term appears only once in the bill. That is Clause 62, submitting information within the information system. I will be brief because we will come to that later. Production of information in information systems. So that is to be read in context of the power requiring production of information within an information system. An operator would be required to produce the information in the information system in a readable format. Now that refers to CAP 533 Electronic Transactions Ordinance. That's the same definition. Information system means a system complying with all the following descriptions. For processing information, storing information, and any other information system which can be used to process information in any other manners, and an information system for retrieval of the information, whether the information is stored within that system or anywhere else. So in the context of Clause 62, as well as the definition of the information system, it is actually the norm in other legislation as well. Whenever a power to require production of information is specified. On the other hand, computer system is more related to the context of this bill. It is about critical computer system of critical infrastructure in this bill's context. It essentially means that it can be a single computer or a computer network, including hardware and software. However, the bill doesn't seek to define the term computer. Many recent legislation, in particular, those related to computer systems, need to keep abreast with time. And we usually don't seek to limit the scope of the term computer. So that's how we define the term computer system. Mr. Lai Tong Kwok, I thank the administration for its explanation. Still, I think that the two terms are highly interchangeable. Do we need to use the term information system and define it? I have doubts. Now, without the term information system, will Clause 62 fail? I don't think so. You are breaking up the concepts into two separate terms. For a layman, computer system simply means a cluster of computer, including hardware and software, and that essentially means information system as well. Anyway, since you have separated the two, let's debate about this later.
Lastly, under the definition of computer system, in Chinese, in English is a computer. It's very clear. But you read the Chinese version, you don't have that sense that it's just one computer, a computer. Computer is a tool, it's an equipment. So perhaps you can reconsider how the Chinese text should be provided. For example, give it a number, give a number to the term, one to signify one computer. Ms. Doreen Kong, through you, Madam Chair, I would like to know that in the definition for computer system, do you include network? But this is something new to Hong Kong. I've been trying to refer to laws in other jurisdictions. When they define a computer system, they would usually include a network. And also, I'm concerned whether the definition is broad enough. If you read this literally, we are really talking about a system for information. But in other jurisdictions, they will cover not just information. They may be referring to also operational technology system. So when we talk about critical computer system, it would have to do with the scope that we try to cover under computer system. We think the definition can cover what Ms. Kong has talked about, such as network. A network of computer is a computer system connected through a network. It means a network of different computers forming such a network. So it refers to a set of computer hardware and software that is organized for certain purposes. As for operating technology, the adjective is really about the function of the system. Actually, the system itself is a computer system. They may use different adjectives to describe the function. So that they can differentiate, or they can distinguish one computer system from another in terms of categorization. We believe our definition can cover the members' suggestions, because we're talking about the basic elements, hardware and software, and not about the functions of the computer system once it's organized. We don't think that there should be a further breakdown. Well, I think the member is trying to clarify whether the definition is good enough for your coverage. Which jurisdictions or laws have you referred to in the drafting? Maybe you can provide such information for members' benefits in our scrutiny. Computer system security incident in relation to a critical computer system means an event that involves access without lawful authority to the critical computer system or any other act done through the critical system and has an adverse effect on the computer system. Ms. Kwong, Doreen Kwong, you have a question? Yes, it's a question about computer system security incident. All right. And also the computer system security incident is really about access without lawful authority to the critical computer system. In our reply to the questions raised last time, adverse effect is defined in such a way that it would have the information and services and integrity and confidentiality or the security of the system will have an actual adverse effect. Mr. Lai, do you have a question about computer system security first? Yes. In your definition, you talk about it would affect the availability, integrity, or confidentiality through certain events or acts. Are there events which will not affect the availability, integrity, or confidentiality of this computer system? Someone may be conducting something malicious, a malicious attack, but it will not affect the security of the computer system. Well, the Chinese text here is not clear, but the English version is easy to read. It doesn't cause me any problem, but when I read the Chinese text, then I have the problem as I have described. Let me try to respond, and then I'll ask my colleague from the Law Drafting Division to respond. Well, concerning the Chinese text of computer system security, we're not saying that it will only be covered events that would affect the security of the computer system. We are saying that computer system security covers any events or acts that would compromise the availability, integrity, or the state in which the system is protected, and the ability of the system to resist. But because the preceding description is rather long, so you may make this definition somewhat obscure. We're talking about the ability of the system to resist and the state in which the system is protected from such events that may compromise the confidential, the availability, etc. When it's translated into Chinese, we'll have to reverse the order, and we'll talk about what the protection is about, and it may not be as clear as the English version. We're talking about something that will compromise and the system's ability to resist. We believe the use of the Chinese word 会 or will, it means that this is a precondition. I think you are talking about the ability of the system and the state of a system to resist such threats. Understand? There's another term, another question on incident, computer system security incident. In this bill, we have two terms, computer system security and computer system security incident. The two are related in my view, and I have tried to find out the differences between the two. Of course, there are differences. Under the definition or interpretation of computer system security incident, paragraph B, well, it means an event that has an actual adverse effect on the computer system. What do you mean by actual adverse effect? This is different from the term for computer system. You're talking about act, but an incident is an event. An incident is an event. The line in between the two is a very thin one. Really, can you really differentiate, or can you really tell which is which? Can you give us some examples for illustration? Thank you. Actual adverse effect. Please refer to our replies to the legal advisor's questions in paragraph 2. We refer to the definition of adverse effect, and that is the compromise to this accessibility, to the availability, integrity, or confidentiality of the system. So you may wish to refer to this paragraph in the reply. As for incident, it refers to an actual impact, an event that would actually impact on the availability, integrity, or confidentiality of the effect. So there is an actual impact or adverse effect. So that would affect the availability. That may, for example, the service may be stopped, maybe broken down. If there's a hacking event, the system may stop to function, or the core functions cannot be delivered. For example, if in a critical computer system, in the power plant, in the field system, there will be a temperature control system. If this is hacked, so that the functions of the temperature control cannot trigger, for example, the system to switch off in case of a mishap, and this is the result of a hacking incidents, and the functions of the computer system will be affected. That would be what we mean by incident, a computer system security incident with an actual adverse effect. And the operator will have a duty to report such an incident. On the contrary, if it's just a threat, it refers to something that is likely to have an adverse effect. That is a likelihood. This is probable. It's not really about an actual adverse effect. Using the same scenarios that I've talked about, if there's a hacker conducting an attack on the temperature control computer system of a power plant, and if he attempts to do this, but the system is robust and it can resist the attack, so it's a threat. In this case, the operator is not under an obligation to report the threat. So one is an actual adverse effect. One only carries an attempt to conduct an attack, and the attack is likely to cause harm. So that's the difference between the two. And there are different consequences. If there's an incident, then a report is warranted. If it's a threat, the reporter is not obliged to disclose it, and the commissioner is empowered to conduct an investigation, a direct investigation into such a threat. I hope this addresses Mr. Kwong's questions. Madam Chair, when it comes to computer system security incidents and computer system security threat, both should have a simple definition so as to ensure a wide coverage. If I can understand what is covered in the definition, how can I make a report? Under the definition of computer system security incident, Madam Chair, you have asked them to tell us, the administration to tell us, what other jurisdictions have been referred to. Well, in those jurisdictions, when they define an incident vis-a-vis a threat, it's very simple. One is an imminent threat, imminent incident. The other is an actual incident which has already happened. And then that one is an act, the other is an event. So they would just talk about an act or an activity, and they would not be talking about an event. And you look at the definition of a computer system security incident, A and B. We don't need A1. Why do we need to talk about the element of access? Because in B, you are talking about an effect on the computer. You don't need anything on access. It's already clear enough. Without this element, can the DOJ and the administration explain why? Let me quickly respond to that. We have referred to the UK on the definition of incident, and Australia too. Also has a similar definition, which we have make reference to, as to whether we need this element of access. Well, the Australian law refer to access. We have referred to many jurisdictions. We make reference to these jurisdictions, and as a consolidated view, we believe that the current wording can reflect our legislative intent.
我懇請局方
Mr. Kong, thank you, Madam Chair. May the administration let us know more clearly which one you're referring to? In relation to the law of Australia, it doesn't refer to access. I'm not saying other jurisdictions are necessarily better than ours. But can the administration provide me with the relevant legislation you have drawn reference from so that I can have a look after the meeting? Thank you. DOJ. Thank you, Madam Chair. Thank you, Mr. Kong. As the Deputy Secretary mentioned, in preparing the definitions of different terms, we've drawn reference from the pieces of legislation of different jurisdictions. We've also taken into account the actual circumstances in Hong Kong. Is there any jurisdiction referring to access? Mr. Kong can refer to Australia's Security of Critical Infrastructure Act 2018 in 12 capital M in the definition of cybersecurity incident. It mentions unauthorized access. They also use the concept of event. In the provisions of Australia, they are even more complicated than ours. Authorized access, modification, or impairment. For every word, a more complicated definition is provided. So we didn't follow the definitions used in Australia. As Mr. Kong said, if the definition is too complicated, it might be less reader-friendly. We also drawn reference from the legislation in Singapore. As members also mentioned, we separated incidents from threats. We've drawn reference from the Singapore legislation in relation to this distinction. The main distinction is that for events, for incidents, they have to be reported, whereas for threats, they do not have to be reported. But the Commissioner has the power to look into threats as well. In relation to the legislation of the UK, for the definition of incidents, they also use events. The definition of different jurisdictions varies from one to another. There is no one that is the most direct or the simplest. After all, in preparing the definitions, we need to strike a balance. First of all, we need to achieve clarity. At the same time, it cannot be too complicated or it cannot be too rigid. This suggested definition is a result of our balance. Ms. Elizabeth Kwok. We'll take a break after the definition of the next term. I'll let Ms. Elizabeth Kwok and Mr. Benson Look ask their questions first. In relation to security incidents and security threats, actual adverse effects, the definition needs to be clear as the industry has related. Just now we talked about availability, integrity, as well as confidentiality. This is a somewhat good summary. For the computer system security threat, if there are loopholes in the computer system, say in some cases, the company leaves the back end of the system. Can we address the situation when the company has made available a backdoor of the computer system? Be it incident or threats. We mentioned static data, transient data, as well as dynamic data. we touched upon this point, especially for static transient data. Have we already addressed the security of this type of data? Thank you for your question. In relation to the definition of computer system security, it is supposed to cover any defects or the backdoor left by a company. We talk about resistance or the status. If the system comes with a loophole, and if the computer system is subject to any effect or attacks, the resistance capability is more easily compromised. So I think the definition actually covers what you mentioned. If there are loopholes within the computer system, say if there are defects, but then no remedial measures have been taken affecting the resistant capability of the computer system, the resistant capability or resilience of the computer system is affected in relation to dynamic or static data. What we mentioned covers the information stored in the computer system. Computer system security mentions the information stored and transmitted or processed by or accessible via the system. So we believe this is already covered under computer system security. Thank you. Next, Mr. Benson Lok. Thank you, Madam Chair. In relation to computer system security incident and threats, in the provisions the threat is likely to have an adverse effect on the computer system security of the critical computer system, whereas computer system security incident has an actual adverse effect on the computer system security. Say if a firewall can withstand an attack, it will be classified as a threat, whereas if it fails to protect the system, then it becomes a security incident and it has to be reported. Is that correct? Can I have a quick answer first? Yes, you're correct, Mr. Benson Lok. This leads to an interesting situation. This bill protects critical infrastructures. If there are daily attempts at the computer system of critical infrastructures, say if there are numerous attempts of the attack, then the administration doesn't provide any assistance to the critical infrastructures. And if one day an accident happens, then it has to be reported. And only then it has to be reported. Is that correct? Deputy Secretary. Yes, indeed. It doesn't have to be reported. Your understanding is correct. The reporting mechanism may be of great concern to operators. If incidents have to be reported, if threats have to be reported, be they major or minor, there will be an impact on operators. As member mentioned, these attacks may happen from time to time. There are always such attempts. And this bill seeks to improve the resilience of computer systems. And we want to enhance the preventive obligation If the computer system can withstand or resist the attack, then it won't be affected. But threats are always here, so we don't require the operator to report threats. That being the case, in the emergency response plan or in the computer system security management plan or in Schedule 3, that is the computer system security management plan, there needs to be a guideline. Operators have to identify, assess, monitor, or respond to and mitigate the risks relating to computer system security. So operators need to do so, that is to identify, assess, monitor, respond to, and mitigate the risks relating to computer system security of the critical computer system concerned. This responsibility is imposed on the operator. We require operators to implement a computer system security management plan so that operators don't have to report these threats, but at the same time they have to guard against these threats. Mr. Benson Long is frowning. Your question isn't answered? Well, I understand. I understand there were daily attacks or attack attempts. I suggest that the administration set out regular reporting mechanism in the COP. In day-to-day communication, if suspected major attack is identified or attack at a higher level is identified, the administration should chip in and help. The Commissioner has investigation power. Can you explain that to Mr. Benson Lo? Thank you, Madam Chair. Thank you, Mr. Benson Lo. As I mentioned, in the event of these threats, the responsibility the operator has a responsibility, but in the case of such threats, the Commissioner can take the initiative to probe into such threats. In Clause 4, brackets E, the Commissioner has the responsibility to monitor, investigate, and respond to computer system security threats and computer system security incidents in respect of the critical computer systems of critical infrastructures. The Commissioner needs to obtain information from operators. In the case of any threats, the Commissioner, in a course of investigation, can be given information about the daily attacks, but the operator manages to guard against these attacks. The Commissioner will in a position to provide information in relation to any follow-up. Apart from this function, our policy purpose is not to impose additional responsibilities on operators. It is not a mandatory reporting mechanism for operators. Instead, the operator can take the initiative to reach out to the Commissioner. Well, when we go to Part 5, we'll talk about early intervention. The Commissioner needs to know of the threats before they can early intervene in the situation. Mr. Lai Tong Kok, in the administration's response to the legal advisor, I'd like to follow up on the actual adverse effect, who is to determine whether it is an adverse effect? Will the standard be subjective or objective? If one determines there is an adverse effect subjectively, and if that is not in line with the Commissioner's decision, how will we deal with the situation? The administration already said that the COP is not legally binding. It serves as a reference. It doesn't have any legal effect. In case of any argument, we will have to decide on which determination or which decision is the ultimate decision, or is the right one, so to speak. If we get this right, we can prevent many unnecessary misunderstandings. Yes, thank you, Mr. Lai. In relation to the determination of adverse effects or incidents, in clause 28, if a CI operator becomes aware that a computer system security incident has occurred in respect of a critical computer system of a critical infrastructure, the operator must notify the Commissioner on the incident in accordance with subsection 2. And that is a factual incident. We have to have regard to of individual circumstances. We'll provide more examples in the COP for the reference of operators. In the legislation, we may not be able to set out an exhaustive list of incidents. Or what does becoming aware mean? If one needs to conduct preliminary investigation, if an incident is not recognized as an incident, then we won't consider that the CI operator has already become aware of the incident. Therefore, we empower the Commissioner to intervene earlier in order to start investigation. As Madam Chair said, in this connection, we have a few provisions and they seek to achieve complementarity. They are also interlinked. When we go to that stage, we'll explain to members in detail how to report incidents, how to intervene earlier. All these are interlinked with the definition, and they will provide a background for members to understand the definition better. DS, we asked you many questions on the definition of these two words. Just now, you mentioned clause 28, and we understand what becomes aware mean. Just now, Mr. Lai asked you the definition of incident. Do you adopt a subjective or objective standard? Or is it the subjective determination of the CI operator when it comes to an actual adverse effect? Have you drawn reference from other jurisdictions?
Administration. Thank you, Chair. Let me put it this way. We discussed the concept of adverse impacts. The concept is adopted by the UK and Singapore. However, their law doesn't specify the person who define what constitutes an adverse effect. Say, for clause 28, it's about an obligation to notify the incidents. It would be a criminal offense for a contravention. So of course, that is based on the subjective point of view of the operator. Supposedly, everyone should understand the definition of the term in the law, but whether the operator is subjectively aware of an adverse event is another matter. Now, the Commissioner has the responsibility to assess whether the security management plan is sufficient. The Commissioner may find the security management plan lacking in terms of addressing adverse events. So that is a judgment to be made by the Commissioner. And if the receiving party of the direction does not agree with the decision made by the Commissioner, they have a right to appeal the decision. So who should be the one to define what an adverse incident is depends on the specific provisions. Mr. Lai, I think we have to leave the discussion until later because I haven't heard any concrete answers from the administration. We ask these questions because we would like to avoid any gray areas when the ordinance is enforced. Mr. Ma Fung Kwok and Ms. Doreen Kong, are your questions related to the definitions? So let's continue with the discussion. Mr. Ma Fung Kwok, thank you. My questions are similar to those of Mr. Lai Tong Kwok. The legal advisor mentioned that the term adverse effect is adopted by several jurisdictions, but I really want the administration to define and narrow down the scope of adverse effects. Now, in September 2021, in another piece of legislation, or the country's regulation on protecting the security of critical information infrastructure, the scope of the relevant industries and adverse events were clearly defined. For example, important and critical information system and internet infrastructure, information leakage from which would severely jeopardize national security. Now, in Hong Kong's context, even the LCSD would consider national security and internet security when they award the venues for organizers. So why can't we define the term more clearly in the bill to avoid misunderstanding? Administration. I thank Mr. Ma for his questions. Concerning the incidents and threats covered by the bill, we have explained the definitions, and Mr. Ma brought up a new concept, that is the definitions of the relevant regulations of the country. Now, the country's regulation has a much wider coverage than ours. As we have explained in the previous meeting, we are just focusing on a narrow niche of internet security, that is computer system security. For the wider internet security concept, it would indeed cover what Mr. Ma Fong Kwok mentioned. We will wait for the completion of the study conducted by the Law Reform Commission before we decide extending the legislation to other areas. Now, under the Safeguarding National Security Ordinance, there is a definition for public infrastructure. So for areas beyond the bill involving the national security of public infrastructure, these are dealt with by the Safeguarding National Security Ordinance. We would like this bill to be more targeted on addressing the threat and risk pertaining to critical computer system. So that's why we haven't adopted a wider or broader definition, because the coverage of the laws are different. Next, Ms. Doreen Kong. Thank you, Chair. I'm still on the point of incidents. Now, there is a problem about how the definition is drafted. When there is a security incident, time is of essence. It may happen at the split of a second. Now, it seems that we rely on the operator to make a judgment on whether the incident constitutes actual adverse impact. I think it is a pressure on the operator to make such a judgment in the split of a second. Now, Part B requires the operator to make a judgment on whether the incident carries an adverse effect. Or actual adverse effects. In other jurisdictions, however, they provide an objective definition for an incident, that is, something that prejudices the security of the system. No judgment on effect is needed. So whenever there is an incident, when it jeopardizes the security of the computer system, that's it. That's not the definition we are using. We are very subtle. We require the incident to carry an actual adverse effect. The verb jeopardize is not used. So I hope the administration can think again whether this is how we like the definition to be. It really puts us at a passive position. It's very passive. Also, the administration referred us to the Australian law in 2018. Well, actually, it has been replaced by an updated version in 2024. Now, following our definition, for instance, what about a power outage affecting the operation of this computer system? According to your definition, no reporting is needed because first, it doesn't meet the conditions in A, no assessment was conducted, nothing is done to the computer system. So system failure due to power outage is not a computer security incident. It only fulfills conditions in Part B but not Part A, so it is not an incident, according to the definition. Deputy Secretary, I thank Ms. Kong for her questions. You mentioned the practice in other jurisdictions. In fact, we didn't just rely on a single jurisdiction. concerning the term actual adverse effects. It has come to our attention that the Electronic Communications Network Regulation Ordinance 2018, the definition for incidents includes the term actual adverse effect. That's one. Second, the U.S. Homeland Security Act 2022 defines incidents as an occurrence that actually or imminently jeopardizes something. So maybe the wordings are a bit different, but the term actual is used. The concept is there. So in our opinion, using the term actual to define incidents is necessary because it is clearer. If we require the operator to submit a report for incidents even without an actual effect, that would cause unnecessary regulatory burden on the operators. It would make the operators very anxious because there are a lot of threats on a daily basis warranting reports. That would impose obstacles to the daily operations of the operators. That's why, having made a reference to the ordinances, the legislation in other jurisdictions, the concept of actual is necessary. And also, it is more objective. Now, if the usability and confidentiality of services is jeopardized, well, actual disruption of service is an objective indicator warranting report. Now, power outage does not require a report. Or should I say, a power outage not arising from a cyber attack, that is not something that an operator needs to report. It may be due to dropping a wattage or technical failure, and that is not a reportable scope. Now, whether Part A applies, that is gaining access without lawful authority, well, that would be something that warrants reporting. A mere technical failure does not require a report. So we are focusing on computer system security. Technical or mechanical failures are not conditions that require reporting. Now, if a power outage occurs, we need to find out whether it arises from hacking or a mechanical failure. That is something we need to clarify immediately. So that's why we have relaxed the reporting limit from 2 hours to 12 hours while empowering the commissioner to intervene at an early stage. So the bill does cover various scenarios. And it has taken into consideration whether the operator is aware of the reasons for the service disruption. Members, this is what I suggest. You have all put forward your views concerning the two definitions. Examples were quoted just now for us to understand the concept better. When we come to the relevant provisions, let us revisit whether the definitions are fit for purpose. That is, it can protect the security of computer system of critical infrastructure while not imposing significant burden on the operator. Now let's take a 10 minutes break. Let's resume at 5:15.